meron tayong MCQ. You can share screen agad para meron yung din. Okay, sige, sige. Baka yung gusto mo. Ako, sige. Sama kita.
Hello, good morning. Good morning, everyone. Hello, welcome to Breakout session number one. We will start in 5 minutes. Or, hello, Jess, my co author. Thank you, Dean Glenn. Okay, we can start now. To our honored guests, officials of the Legal Education Board, all the partners who organized the first Philippine Clinical Legal Education Summit, good morning. Good morning, everyone. Maayong buntag. It is our privilege to have this opportunity to present our research paper. I would especially thank our CLEP partner, the Asia Foundation, Attorney Fatima, Attorney Toff, and Nikki for their guidance. With my technical team here, I would like also to thank you for your assistance. So the title of this paper is CLEP for Empowerment through Cooperative Initiatives in ICCs or Indigenous Cultural Communities and IPs or Indigenous Peoples with my co-author, the future attorney, Ms. Jessica Wu, our fourth year law student and a law student practitioner. First, may I commend and congratulate the PCLE Summit organizers for the paper presentations and workshops today. The sharing of ideas, proposals, and best practices expand the coverage and impact of the clinical legal education. Since the time when CLEP was first being established, they mentioned that every CLEP in each law school must find its niche or specialty depending on the prevailing needs of each community. And we must clearly identify target communities as beneficiaries. So, we had consultations with our university stakeholders, law faculty, and students. And to put into context our paper, we are a state university, and each college under the university were required to produce extension or community outreach programs. For the College of Law, the first year or phase one is the proposal making or drafting. So we have proposed that CLEP will be our extension program. And before it can be funded by the university, it needs research proposal and needs assessment. So we will choose a community to which they will be the beneficiary of our services provided or knowledge transferred. For year two or phase two of our implementation, we will have the establishment of the CLEP and the trainings that we will be providing. And on phase three, or at the end of the third year, or let's say 5 years, the program will be evaluated on its impact to the program and it costs to the community. So let me proceed to the introduction. Next slide, please. Bukidnon is a province in the heart of Mindanao. It has multiple indigenous cultural communities or ICCs from different tribes and subtribes whose social or cultural identity is distinct from the mainstream society. Like other provinces, poverty incidence in Bukidnon is seen to be the highest in ICCs. Having one of the highest population of IPs or indigenous peoples, it would seem to explain why Bukidnon is one of the poorest provinces. But with all the natural resources within the ancestral domains of the ICCs, this should not have been the case. The marginalization of IPs make them vulnerable to exploitation and discrimination, especially in the area of economic development. The right to self governance and means of empowerment is embodied in the IPRA or Indigenous Peoples' Rights Act, which determines their right to pursue economic, social, and cultural development. Moreover, the Cooperative Development Authority or CDA and the National Commission on Indigenous Peoples or NCIP strengthened the IPRA provision on self-governance through a joint memorandum circular number 1 series of 2018 entitled Guidelines Governing Promotion, Organization, Registration, Development, and Regulation of Cooperatives to be established by indigenous cultural communities or ICCs and indigenous peoples or IPs. The Buksu CLEP or the Clinical Legal Education Program will therefore help enforce and advocate these rights and guidelines. The CLEP is an important program which bridges the gap between the haves and have-nots in accessing justice. Since Bukidnon State University College of Law is the only university in our province, our research paper seeks to identify the gaps in legal empowerment at the grassroots level in the IPs of Bukidnon, especially in the issue of cooperative initiatives. Due to the geographical location of these ICCs or IPs, most of them are isolated in the mountain areas. Cooperative creation tends to be difficult in its initiation process, and once the organization is set up, challenging in its sustainability. As advocates of the law, the Buksu CLEP is equipped to be the conduit for utilizing social legislation such as the IPRA and providing access to justice for the IPs. A three-pronged approach will be used to address the relative needs of the ICCs and IPs. A long-term goal of our CLEP is to reach a point wherein marginalized, underserved sectors, such as the ICCs or IPs, are given opportunities to be economically secure, truly governing, self governing, and legally empowered. The revised rule of the law student practice of the rules of court through the clinical legal education program of the Legal Education Board and the Supreme Court recognizes university CLEP as legal service providers through provisions of legal advice, representation, drafting of documents, and legal literacy, enforcement, and the like. In this paper, we analyze the principles of law, legal norms, and opinions of scholars or legal experts on topics of CLEP, assessing legal empowerment, development of cooperatives, and the role of CLEP clinics or CLEP in the empowerment of the IPs. The data used in the study are secondary data in the form of documents, books, articles, and papers or journals. This paper also looks into the challenges the IPs face in accessing justice and how university CLEP can be used to mitigate the problems and empower the IPs. We looked at possible avenues for expanding the services of the CLEP, particularly in developing cooperatives in ICCs or IPs. And our primary argument made is that effective clinical legal education program is attainable through efficient programs. Under Zeman's article, a strategic model of legal services identifies the significant social problems facing the community it is serving. While dealing with inevitable daily problems, a strategic legal services program attempts to develop a long term approach of research, reform, and education to deal with the more fundamental issues. Rather than handling cases in a traditional legal aid service, which are relevant to the lawyer's experiences, a strategic program sets a bigger impact and is deemed more sustainable. For instance, there are over 45 clinics in Ontario operating many features of the American welfare rights model of legal services. Next slide, please. Some are specialty clinics providing services to ethnic communities. Our clinics dealing with underprivileged groups in the community, such as children or the handicapped, environment, or immigration. These CLEs are involved in some of the most significant and far reaching projects affecting the low income persons in Canada. Each CLEP established eligibility guidelines and service priorities so that caseload accepted is not solely on the basis of individual merit, but with a reference for allocating limited resources to the areas of service that they determine will be most effective. Although cooperatives are viewed as an important vehicle for community development, the relationship between IP communities and the CLEP is a neglected research issue. Because of this neglect, no framework for analysis of the impact of legal empowerment between them exists. And in this paper, we help define a new framework for analyzing the complete impact and efforts of CLEP in IP communities, specifically IP cooperatives, as community development agents. The long term objective is to reach a point where the underserved, again, and marginalized sectors are given opportunities to be economically secure, truly self governing, and legally empowered. So, the objectives of our paper is that we will conduct a legal empowerment assessment of the ICCs and IPs and provide capacity building training through the local CLEP clinic of the Bukidnon State University College of Law, CLEP, specifically conduct a group focused approach in a pilot community to capacitate the IPs who would like to venture into an enterprise, evaluate and assess the level of legal empowerment necessary to assist the ICCs in their cooperative initiatives through CLEP, and provide capacity building and use interventions to address the gaps in the ICC's legal empowerment for their economic development. So, our research question is: what are the benefits of indigenous peoples CLEP? Under the revised Rule 138-A, the practice areas of law student practitioners subject to the supervision and approval of a supervising lawyer, a certified law student practitioner may, for Level 1 certification, Item 4, 6, and 7, drafting legal documents, provide public legal orientation, and assist in public interest advocacies for policy formulation and implementation, will be the focus of our CLEP and specializing on IPs, issues, and cases. Further, we recognize the need for IPs to be legally empowered and proactive in the economic growth and development of their communities. As gatekeepers to the profession, law schools have the unique opportunity and obligation to make access to justice a more central social priority. The university CLEP can contribute to the solution of the crisis in access to justice. But CLEP could mean much more than traditional legal representation. Instead, we can think of CLEP as providing public access to law that is preventive and proactive and protective, that brings change and hope, and that relieves poverty and promotes prosperity. We can think of CLEP as providing public access to legal information, legal advice, and legal education. So, what does the term legal empowerment mean? Even in a casual perusal of development literature, there are dozens of definitions and descriptions. But the most fitting is in a 2000 report for the US Agency for International Development, and it suggests that legal empowerment of the poor occurs when the poor, their supporters, or governments, employing legal and other means, create rights, capacities, and opportunities for the poor that give them new power to use the law and legal tools to escape poverty and marginalization. Empowerment is a process and it in itself and a means of escaping poverty. So how do we assess legal empowerment? The identification of regions of this empowerment or comparisons across different problem types, populations, and nations could both benefit from the use of subjective legal empowerment. Impact evaluation is one of the areas where the measure has the most promise, and legal interventions and their effects are notoriously challenging to quantify. So, the idea of subjective legal empowerment allows us to gauge how a policy or action impacts the targeted population's perceived capacity to use the law to address its issues. Because it captures the perceptions and preferences of individuals who are meant to gain from the intervention, measure is useful and can be easily utilized. It is challenging to demonstrate cause and effect links, but it is likely that the beneficiaries are positively affected if the intervention is followed by an increase in the perceived strength of the legal system. In a United Nations report, the Lumans of northwestern Mindanao answered when they were asked about their needs and aspiration. The first or main demand is full implementation of the IPRA in order to develop their land and regain territories. Second need is education. Third are demands for livelihood programs and financial assistance. Fourth, they demanded a measure of self-governance and respect for their cultures. Fifth, they demand the means to protect themselves and their resources. And sixth, they demand improved infrastructure as a means for increased productivity. And finally, they are requesting more meaningful participation in the development process. So the third to seventh need and aspiration will be the focus of the IP CLEP. So why IP or ICC cooperatives? Cooperatives play a vital role in the Philippine economy. In a report, the cooperative sector made significant contribution in 2018 to 517 billion pesos. Cooperatives are intended to develop communities through the production of high quality goods and provision of better services. Our target community will develop metal products. They are blacksmith, and aside from agricultural products, they produce other artistic products also. So cooperatives could help by patronizing only standardized products and services of high quality. Hence, different types of cooperatives will strive to improve their own goods and services to stand competition with business establishments. This in turn will be instrumental in improving the life in the country. In 2001, the United Nations produced guidelines aimed at creating a supportive environment for the development of cooperatives. And the IBP further recently launched the Inclusive Growth, Inclusive Business Project, on which our CLEP plans to coordinate with the IBP local chapter in order to implement our proposal and sustain this program. We also found out that governments need to provide a supportive framework for cooperative development. In one article written by the IBP National President and member of our law faculty, Attorney Bert Estrada, and his co-author identified a major issue that many of our tribal leaders and ICCs face. That is the continued disconnect between the IPRA and other laws such as the Local Government Code and the Cooperative Law. The establishment or development of IPs or ICC cooperatives will cause the creation of juridical personality required by government agencies for them to be recognized and included in the development plans of the LGUs. Grants and support from financial institutions will also be prioritized, and any other purposes required in legitimate business transactions will be available. Through the collective effort of people bound by a common interest, the marginalized sector is given an opportunity to be part of nation building and to experience economic progress at the grassroots level. Having a registered cooperative gives the organization a recognized or even a preferred juridical personality when dealing with financial institutions and LGUs. Second, it is imperative that the state empowers the IPs as it will bring about stability and cultural integrity within the domain. In the empowerment of cooperatives, there are considerable implications for the creation of food self sufficiency, and the welfare of cooperative members will be better, and the development of human resources in IP cooperatives will increase. A series of forum for guidance and education, as well as human resource development in cooperatives, may be designed through a training or module and will be carried out by our CLEP. There will be a design on a survey. We will conduct interview and analyze statistical data to support this paper, which will be further evaluated and disseminated in the future. In addition to information and training, cooperative development may also require certain financial support, including startup funds for the purchase of machinery, equipment, and all other financial needs, and also access to credit. So the CLEP law student practitioners may draft policy paper for government and international donors to develop appropriate programs, including partial participation in machinery purchase through distribution of grants, leasing rules, and access to discretionary credits for investments and working capital. So, as a recommendation, we will promote the cooperatives through information campaign and legal framework for cooperative efforts. Under Section 14 of the CDA NCIP Joint Memorandum Circular, the documentary requirements that the IP cooperative shall submit with the help and assistance of the law students under CLEP uh, will be drafted, and the CLEP, as part of its information dissemination, may create a training design for the ICCs in the processes and procedures of developing a cooperative and assist in compliance with the submission of the documentary requirements in their own language and context. After the establishment of the ICCs or IP cooperatives, there should also be orientation on the annual submission of required documents and updating of general information with the CDA for its sustainability. As part of information and training services, it is necessary to establish mechanisms for systematic experience sharing among existing cooperatives. There has been papers on rural cooperative developments. When they share experiences with other cooperatives, they increase their potential to have a bigger membership and bigger capital. So, a successful cooperative is an excellent example that should be followed by other existing or potential cooperatives. And this should be advertised through their experience sharing. So, those will be the recommendation of this paper. And next slide, please. On the future research, in the future, we will be um, drafting a paper also on the evaluation of the needs assessment and assessment of the legal empowerment impact on the IP cooperatives of the CLEP. And that will be all. Thank you. Are there questions?
Good morning, everyone. Good morning, everyone. I would like to ask if my presentation is visible and if I am audible. Thank you. Once again, good morning, everyone, especially to our distinguished guests, justices, judges, deans, and my fellow law student practitioners. I am Claire Marie Rojas, a fourth year law student and law student practitioner of the University of Cebu School of Law. My paper is entitled Bringing the Law Closer to the People, an analysis on the impact of CLEP to the communities that we serve. Before I begin, I would like to present the outline of my paper presentation. First is the introduction of UC's CLEP courses to provide the context of my paper. Second, the discussion proper. to discuss the CLEP activities with their corresponding impacts on the beneficiary communities. And finally, the analysis to identify what impact is common among all communities, despite the fact that they were subjects of different activities. Proceeding now to the first part of my paper presentation, the University of Cebu has two CLEP courses, CLEP 1 and CLEP 2. Each course has 5 prongs each. These prongs are the following. First, capacity building. Law student practitioners conduct two capacity building activities every month for two beneficiary communities. One community is inside the university, for example, the nursing students or the faculty of a different department. The second prong is litigation. Here, law student practitioners assist indigent clients in the litigation of their cases. They either draft court documents, such as pleadings, or they conduct client interviews under the direct supervision of our supervising lawyers. The third prong is the online help desk, where law student practitioners help out any person who needs legal advice and who contact us through our Facebook page and mobile numbers. Our fourth prong is the educational podcast entitled Lex Get Loud. Here, 3 episodes are published every month, produced by our law student practitioners. They invite different lawyers who are able to talk and discuss the different areas of laws in their practice. And finally, the fifth prong, we have the Green Legal Clinic. Now, why does this prong have its own slide? That's because the Green Legal Clinic is the topic of my paper. Essentially, my paper will analyze the impacts of the Green Legal Clinic's activities on the beneficiary communities. The Green Legal Clinic is a specialized law clinic for the environment where law student practitioners conduct various activities geared towards the protection and conservation of the environment. It can either be through law enforcement, environmental campaigns, and the conduct of capacity building activities. In this prong, we have partnered with various non-governmental organizations such as the Philippine Justice Center and Oceana Philippines. In this paper, the Green Legal Clinic's activities are limited to 3 activities. Out of the many activities conducted by our Green Legal Clinic, the 3 activities that are analyzed in this paper are the following. First, we have Project RPEC Sugbo, which is in partnership with the Cebu Provincial Police Office through its Police Advisory Council. Here, law student practitioners conduct workshops to various PNP offices across the province of Cebu about the rules of procedure for environmental cases with special emphasis on SLAP suits. Second, we have the Mandaue City Environmental Code. This is in partnership with the Mandaue City LGU, where law student practitioners and supervising lawyers conduct writing workshops to legislative and executive officials of the LGU in order to help them codify thousands of ordinances geared towards the protection of the environment. And finally, the last activity that will be analyzed in this paper is the island-wide meeting of women environmental defenders. In this meeting, law student practitioners invited various environmental women, or rather women environmental defenders in the Visayas in order to give them an avenue to share their best practices and to facilitate the creation of networks among different organizations to enhance a support or a stronger support system. To assess the impacts of the 3 activities that I have just discussed, I adopted a program logic model with subjective quality indicators as the framework for the paper. The program logic model is the logical flow of 4 components to assess the outcome of an activity. These 4 components are the following: the beneficiary community's problems, the CLEP activity through the Green Legal Clinic, which aims to address said problems, the recipients of the activity, who are the beneficiary communities themselves, and finally, the outcomes or the impacts of such activities on the beneficiary communities. The subjective quality indicators provides for the opinions of different persons who are important in the conduct of the CLEP's activities. This could either be the opinions of the partner NGOs, the supervising lawyers, the students, and the beneficiary communities themselves. The opinions are gathered either through interviews and surveys. And if we look at the framework, the input there provides for the people who provided input or opinions concerning the different four components of the program logic model. So, having discussed the framework of the paper, I will now proceed to the second part of my presentation, which is the discussion proper. Preliminarily, before we discuss the opinions or the data gathered from the different interviews and surveys, I would like to introduce the key actors that have paved the way for the university's partnership with various organizations. First, we have Attorney Ria Lydia Espina, the VP Internal and Chairperson of the Law Committee of the Police Advisory Council of the CPPO. Second, we have Ms. Karen Gatos, consultant to the Mandaue City LGU and a member of the Wildlife Conservation Society. And third, we have Ms. Daisel Ordeniza, officer of two non-governmental organizations for the environment, the Cadena Fisherfolk Association and the Pundok Sagop Kalikupan. Attorney Espina paved the way for our partnership with the Police Advisory Council. Ms. Karen Gatos introduced our supervising lawyers to the LGU of Mandaue City, and Ms. Daisel Ordeniza brought together various women environmental defenders in different organizations in Minglanilla, Cebu to attend the island-wide meeting. Minglanilla, by the way, is a province, or rather a municipality in the province of Cebu. So now we shall discuss the data or the flow of the CLEP activity in addressing the different problems of the beneficiary communities and identify, finally, the impacts of each activity on the beneficiary communities. First, we shall identify the impacts brought out by Project RPEC Sugbo. Here, the Police Advisory Council identified one problem. The police officers are not familiar about the rules of procedure for environmental cases. They do not know how to defend themselves in case harassment suits are filed against them as retaliation for enforcing environmental laws. Some even hesitate to prosecute big-time violators of environmental laws because they are afraid of such harassment suits. So, to address this problem, the Police Advisory Council partnered with the University of Cebu in order to formulate and create Project RPEC Cebu. One impact was identified after interviewing two police officers from Carmen and some police officers from Compostela. Carmen and Compostela are two different municipalities in Cebu. The impact that they have identified is that they have improved their knowledge of environmental laws, particularly the rules of procedure for environmental cases. One officer from Carmen even pointed out that it was only during the workshops where he and his colleagues found out that the rules of procedure for environmental cases existed. It was even the first time that they heard of the term SLAP suit. So this is the impact brought about by our Project RPEC Sugbo on the beneficiary communities of the CPPO, or the Cebu Provincial Police Office. Next, we go to the Mandaue City Environmental Code. Here, the problem lies with the Mandaue City officials' unfamiliarity with the proper process of codifying thousands of ordinances into one simplified but complete ordinance. Hence, the university conducted a series of writing workshops that spanned across one whole year to help the LGU draft its environmental code. The writing workshops were attended not only by the Sangguniang members or the legislative officials of Mandaue City, but also the executive officials of Mandaue. Three impacts were identified over the course of the writing workshops. The first impact: the activity pioneered a new process of drafting ordinances that was more collaborative. Usually, ordinances are drafted in a siloed process. The legislative officials or the Sangguniang members would discuss among themselves and draft the ordinance. The executive officials, on the other hand, would merely approve or veto the ordinance. However, according to the respondent in the interview, because of the writing workshops, the participation of the executive officials was not only limited to the mere approval or veto of the ordinance. In fact, the executive officials, together with the legislative officials, participated in the discussion and identified which of the thousands of ordinances are to be retained or copied or carried over to the environmental code, and which ordinances already do not apply or are not already applicable in the current environmental situation of the LGU. Hence, there is more collaboration among the different types of officials in the drafting of an environmental code. Second impact is that the activity ensured that Mandaue City will have a Mandaue City-centric environmental code. One of the problems or one of the insights provided by the respondent was that the DILG provided a set of guidelines or a generic template to guide the LGU in the crafting of its environmental code. The problem with this, or one downside to this, is that it was not specific enough to meet the current environmental situation in Mandaue, nor was it specific enough to address potential environmental problems in the LGU. But because of these writing workshops, the LGU of Mandaue City was able to craft an environmental code that ensured specificity and context. The third impact is that the activity improved the officials' knowledge about codifying thousands of ordinances. Hence, they can use their learnings from the writing workshops whenever they want to codify thousands of ordinances about other areas of laws. So these were the three impacts that were identified by our respondent when asked about the impacts of the writing workshops. Finally, we proceed to the last activity through our GLC or the Green Legal Clinic. This is the island-wide meeting for women environmental defenders in Visayas. The problems identified by our respondent were the following. First, lack of knowledge about environmental laws. And second, lack of a strong support system among different organizations in the Visayas. To address such problems, the island-wide meeting was facilitated or was organized by our law student practitioners in order to capacitate our women environmental defenders. Two outcomes were identified after the meeting, or two impacts rather. First is the creation of a network among the Cadena Fisherfolk Association, Pundok Sagop Kalikupan, and the Sitio NOAA organization. These three organizations are from Minglanilla, Cebu. So because of the meeting, three organizations were able to form a support system in order to capacitate the women environmental defenders in that municipality. The second impact identified by our respondent was that the attendees improved their knowledge about environmental laws. Because aside from creating networks during the meeting, the attendees shared their best practices in their respective organization and at the same time asked questions about environmental laws to our law student practitioners. So the two impacts, improved knowledge and the creation of the network, were identified by our respondent in the island-wide meeting of women environmental defenders. That would conclude the discussion proper of my presentation. Now we shall proceed to the last part, the analysis, conclusion, and recommendation. After having identified the different outcomes of the GLC activities, there is one common impact present among all three activities. So if you could look at this Venn diagram, one impact is common, and that is improved knowledge. From the first activity, Project RPEC Sugbo, one impact was identified: improved knowledge about the RPEC and SLAP suits. In the second activity, the Mandaue City Environmental Code, three impacts were identified. First, the creation of a Mandaue-centric code. Second, the pioneering of a new cooperative process. And third, improved knowledge in codifying ordinances. In the third activity, there were two impacts: improved knowledge about environmental laws and the creation of networks. Now, all three activities, you can find that there is one common impact: knowledge. This impact is probably owing to the fact that the activities were conducted just recently, only between the months of August and October 2022. Hence, the most apparent and immediately felt impact by our beneficiary communities is their improved knowledge about different areas of laws, particularly the environment. This is why it is also recommended by the paper that there should be studies on long-term impacts in order to assess how our CLEP activities through the GLC have impacted the beneficiary communities in the long run. So for example, there could be an assessment on the improved statistics for enforcement of, or rather prosecution of, environmental law violations, or there could be an assessment of the quality of programs created through the networks forged during the island-wide meeting. This is one of the limitations of my paper. However, as a final note, I would like to point out that Rule 138A was promulgated to bring justice closer to the people. However, it's only been 3 years since its promulgation. With a relatively new development of the CLEP, there is then a need to determine whether the amendment has indeed brought justice closer to the people. And the answer to that, as far as the University of Cebu is concerned, is in the affirmative. Our activities through the GLC have, in a way, brought justice closer to the people by improving their knowledge about the law, which is in fact the first step. To end my presentation, I would like to quote John Adams, founding father of the United States. He said, "Liberty cannot be preserved without a general knowledge among the people, who have a right to know and who have a desire to know it." So yes, justice has been brought closer to the people through the improvement of their knowledge about the law. But it will not stop there. And our CLEP program will most definitely continue to bring justice closer to our beneficiary communities. Thank you very much, and that will be all for my presentation. Is there any question? For us both, for Miss or for Dean Dekang.
Um, so if you want to have a copy of our presentations, we can email it to you or send you through the leb.gov.ph. And if you want to get a copy of the paper or the presentation, um, both the presentation and the paper will may be given to you. So hi to everyone, all the deans and the law students who are here. Good morning. It's our first time. So, and it's the first paper that we presented. Yes, from Notre Dame. We can have a copy sent to you, sir. Dean Pauline, can you include in your proposal the capacity building for the accounting reportorial requirements? Yes, po. Yes, that's what we are meaning to draft also. Thank you, Dean Pauline.
Good morning. If anyone is interested to read about my paper, we can message each other through my email and then I will send a copy of my paper to you. Thank you very much. I thank you din po, Dean Alshade.
I think with the revised rule, one of the things that it did was that it institutionalized um, the reality that there is so much inequality. There are marginalized and vulnerable sectors, and we have to do something about it. Before, we only hear about it. Some are more aware than others. But since now we have the revised rule, and in the revised rule, again, there's that preferential treatment for the marginalized and vulnerable sectors, then it becomes a mandate.
We should consider CLEP as a way of getting students to be practice ready. This means they are exposed to the handling of actual cases and matters, dealing not only with clients but also with the courts, administrative agencies, institutions. CLEP teaches our law students what it means to be a lawyer in the real world, rather than being limited to cold and clammy books and cases, and then they get surprised when they actually interact with the people when they are already in the law office.
I think with the revised rule, one of the things that it did was that it institutionalized the reality that there is so much inequality. There are marginalized and vulnerable sectors, and we have to do something about it. Before, we only hear about it. Some are more aware than others, but since now we have the revised rule, and in the revised rule, again, there's that preferential treatment for the marginalized and vulnerable sectors, then it becomes a mandate.
We should consider CLEP as a way of getting students to be practice ready. This means they are exposed to the handling of actual cases and matters, dealing not only with clients but also with the courts, administrative agencies, institutions. CLEP teaches our law students what it means to be a lawyer in the real world, rather than being limited to cold and clammy books and cases, and then they get surprised when they actually interact with the people when they are already in the law office.
Your law school clinic administrators and supervising lawyers are asked to reflect also on what they have been doing already in terms of the exercise of their profession. Like, have they been doing what we were really asked to do in the first place? That is really public service. Law really, the legal profession is public service. But sometimes, or maybe all of the time, when we go into practice already, we forget about that. Our lives are already occupied by more of the interest of our clients and the interest of your interest as a lawyer. You forgot that first and foremost, the legal profession is for public service. We are public servants.
I think the revised rule will help develop lawyers who have heart for those who are in need. We also help an elderly woman who would have been deprived of her property if not for the support of ILAW and the student volunteers. So the importance, I think, is because we immerse ourselves with the legal issues, work with the marginalized and those who need legal assistance. Through the rule, we will be able to form lawyers who will have an understanding not only of the law as it is written, but how it impacts the lives, how the law impacts the lives of the people that we will serve in the future. So I think working under the rule as students, we are able to understand not only the legal problems but also some of the structures of injustice that are facing our country.
With CLEP, the law students are given the opportunity, because they're out in the field, to really rethink, what do I want to be when I become a lawyer? What kind of service do I want to? Do I want to go to litigation? Do I want to go to policy making? You know, in the past, before clinical legal education was really introduced through Rule 1388, law clinics were really mostly litigation clinics. We forgot that lawyers are not just litigators. Lawyers are engineers. They build institutions. Lawyers are policymakers. And this one, CLEP is bringing to the table. Telling the student, what do you want to be? Do you want to go into litigation, policy making, or do you want to go into building institutions?
The first is always a preferential treatment for the poor. We have to realize that we live in a world that there is so much inequality. When we see that people are equal, the reality is, in law and in essence, we want that kind of equality. But factually, there's so much inequality. And access to justice, for example, might sound very good, very well. Everyone can access justice. But because of inequality, it is not true for many people to attain justice. So having that frame of mind of preferential treatment for the poor gives that insight that we must do something to give them, to allow them to attain the equality in law that we want.
Empathy. You know, you must have that in order for you to serve well. Even if in whatever profession you need empathy. service only comes, you only deliver excellent service if you are able to experience what your clients are experiencing, and you are able to give the appropriate service if you have that empathy. The clinical legal education program is the one that provides the opportunity for one to be empathetic, to really care. Yeah, empathy is really care, to really care for your client.
You have to keep your integrity intact because you may not win initially, but it's a process. It's a process of change. Sooner or later, you will succeed. But what is the worth of that success if you give up your integrity?
One must be ethical, or else the services that you give might be, of course, for the client the best. But if it is not ethical, it wouldn't really serve the public, and that would only be for a short run. No, if your service is just to help your client without looking at the repercussions of that help to the community.
You have to be an advocate of your case. The law is the basis, but you also have the factual circumstances. But these are tools. So if you are an advocate, you have to be creative. You have to stand by and stand for your clients. No, you can't just tell them, talo na tayo. No? You have to fight for them. You have to believe in that case. And that's what being an advocate is. No? You don't just give up. You really fight for them, and you give it all.
A law student practitioner has to have that attention to detail because we have to deal with the nitty-gritty of the law, and how do we use that nitty-gritty of the law to protect the rights of our clients.
Of course, professionalism. Yeah, we just don't have to have the empathy or be ethical. We must know our work well. We must be excellent in what we do. We must be on time. We study. We know to research, and that's professionalism.
With CLEP, we are training our law student practitioners to be practice ready, so as them not to be shocked when it comes to actually filing pleadings or actually filing cases in court. They won't be shocked anymore when it comes to really dealing with anything that is connected to the legal profession.
I'm looking forward for a day to learn how to work with, argue with, and be with our lawyer friends in the courtroom and pursue, because I think it's important. It's not only that because you'll experience it as you will do it later when you become a lawyer, but more importantly is you can journey more with the clients that we serve. Not only in the interviews and writing the affidavits, but also really championing their cause in a way. So I think it's exciting, and also hopefully if there are more and more student practitioners who are doing it for the clients, then we will bring access to more of the Filipinos in need of support of legal aid in a way.
With me having 5 months of being a law student practitioner, it taught me to be more service-oriented. It taught me how to go beyond what is written in the law. I was taught, and maybe my other co-law student practitioners, where we were taught to be more service-oriented. We have to be compassionate with every client that we encounter, and we are to make sure that with our legal knowledge, we are able to help those who have less in life.